Hello, welcome to the new video in this series of jurisprudence. In the last video, we saw the difference between positive school of law and natural school of law. In this video, we'll look into the definitions of jurisprudence provided by prominent legal scholars. John Austin, jurisprudence is the philosophy of positive law. Positive law is the law set by political superiors to political inferiors. So, Austin, a legal positivist, focused on law as a set of commands from sovereign authority. He viewed jurisprudence as study of this law and their relationship to human behavior. Roscoe Pond said that jurisprudence is a science of law, using the term law in the juridical sense as denoting the body of principles recognized or enforced by public and regular tribunals in the administration of justice. So, Pond emphasized the practical application of law and its role in society. His definition reflects his belief in law as a tool for social engineering, guiding and controlling social behavior. Salmond said that jurisprudence is a science of the first principles of civil law. Salmond considers jurisprudence as a study of fundamental principles that form the basis of legal systems. His approach is analytical, focusing on the underlying structures of law. Holmes said that the life of the law has not been logic, it has been experience. The felt necessities of the time, the prevalent moral and political theories, intuition of public policies, avowed or unconscious, even the prejudice which judges share with their fellow men have a good deal more to do than a syllogism in determining the rules by which men should be governed. So Holmes viewed jurisprudence as a reflection of societal experiences and necessities rather than purely logical reasoning. His definitions highlights the pragmatic and evolving nature of law. So these are the four, and now we'll move into the other definitions. The fifth one is by Kelsen. Jurisprudence is a science of pure law. It is a theory of norms as distinguished from the science of facts. It is considered with the law as it is. It is concerned with the law as it is, not as it ought to be. So Kelsen's pure theory of law focuses on law as a system of norms. He believed jurisprudence should be free from social, moral, or political considerations, focusing solely on the structure and function of legal norms. H.L.A. Hart provided the definition that jurisprudence is the study of general and fundamental questions about the nature of law, legal systems, and legal reasoning. Hart's definition encapsulates his approach to jurisprudence as a study that addresses the foundational questions about what law is, how it functions, and how it should be interpreted. Jurisprudence is the knowledge of things divine and human, the science of just and unjust. A Roman philosopher and lawyer provided a broad definition that includes both ethical and legal aspects of law, emphasizing the moral foundations of legal principles. Julius Stone said that jurisprudence is the lawyer's extraversion. It is a lawyer's examination of precepts, ideals, and techniques of law in the light derived from present knowledge in the discipline other than the law. So, Stone's definition highlights the interdisciplinary nature of jurisprudence, suggesting that it involves looking at legal principles through lenses of other fields such as sociology, psychology, and philosophy. Lord Lloyd said that Jurisprudence is the study and systematic arrangement of general principles of law. So he sees jurisprudence as a systematic and organized study of the overreaching principles that govern legal systems and providing a framework for understanding and applying the law. And the last definition we look into is by Jeremy Bentham. Jeremy Bentham, jurisprudence is the art of knowing what has been done in the legal system in the past. So Bentham, a utilitarian, viewed jurisprudence as a practical study focused on understanding existing legal practices and institutions to improve future legislation. So this is it. This definition illustrates the diversity of thought in the field of jurisprudence, reflecting different perspectives on what law is and how it should be studied and how what its ultimate purpose should be. Now, in the next lecture, we'll look into the relationship between law and morality in detail. Thank you for watching this video.